Testing, testing.
I'm Assistant Attorney General Morgan Damaro.
All right. Good evening. This is a study session for the West Valley School District Board of Directors on Tuesday, February 13, 6 p.m. I'll call the meeting to order with the Pledge of Allegiance, and the flag is right over my right shoulder, so stage left. Ready? Begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so all of the school board members, just for the record, on tape are here except for Mr. Strong, who we will dismiss, or I'll make a motion to dismiss because his daughter is playing basketball tonight for West Valley High School, so that's occurring now. Item 3 is no changes to the agenda. Item 4, communications will be saved for the regular school board meeting. Item 5 is one discussion item, which the board members are required to, by law, take training periodically. And so we have WVSD's open government recordings on the Open Public Meetings Act, the Open Public Records Act, and records retention. So we have that presentation, and so some of the board members are already out in the audience, and so we'll just go ahead and start. I guess Mr. Heed's not here yet. So Mr. Strong and Mr. Heed are not here. So okay.
Hello, I'm Assistant Attorney General Morgan Damerow. This training provides an overview of the Open Public Meetings Act. It's intended for both the public and public agencies. Our purpose in this training is to provide a greater understanding of the legal requirements of the Open Public Meetings Act. The Act was passed in 1971, a time of a nationwide effort to make government affairs more accessible and more responsive. The purpose of the Act is to provide the public access to information concerning the conduct of state and local government. The law is based on the principle that open government is essential to our free society. The Open Public Meetings Act gives the people of Washington State the opportunity to witness the deliberations and decisions of government. More recently, that's included an opportunity to provide public comment as part of that process. Multi-member governing bodies of state and local agencies such as school boards, city and county councils, and the state commissions must comply with the Open Public Meetings Act. The law states that it is intended that the actions of these governing bodies be taken openly and that their deliberations be conducted in an open manner. Meetings subject to the Act must be open to the public, gavel to gavel, unless the law permits a meeting or part of that meeting to be closed. Thank you for watching, and I hope you find this training informative. This training's purpose is to increase your knowledge of the Open Public Meetings Act. The OPMA is in Chapter 4230 of the RCWs, and this training incorporates updates from the 2022 legislative session. This training video contains 15 short segments. We just discussed Section 1, the history, and Section 2, the purpose of the Act. The remaining segments we will review the scope of the OPMA, what is a governing body, what is a meeting, what is action and final action, travel and gathering, regular meetings, special meetings, remote meetings. We'll also talk about executive sessions, public attendance and comment, minutes, liability, as well as other laws and provide some additional resources to assist you. The Act has several clear requirements, and compliance with them is improved with training. Training can mean the difference between meeting your agency's OPMA obligations and expensive litigation. The Act applies to governing bodies of multi-member public agencies, both state and local. At the state level, public agency includes state boards, commissions, committees, departments, educational institutions, or other state agencies which is created by or pursuant to statute. Public agency does not include the courts or the legislature. For local governments, public agency includes any county, city, school district, special purpose district, or other municipal corporation or political subdivision of the state of Washington. Examples of these include city councils, county councils, school boards, and fire district boards. Public agency may also include a sub-agency of a public agency, which is created by or pursuant to statute, ordinance, or other legislative act. A good example of these includes planning commissions, library or park boards, or commissions. A final group is any policy group whose membership includes representatives of publicly owned utilities formed or pursuant to Washington laws when meeting together or as or on behalf of participants who have contracted for the output of generating plants being planned or built by an agency operating them. In some cases, an entity which is not an agency may still be subject to the OPMA when it is the functional equivalent of a public agency. This determination depends on whether it performs a governmental function, receives governmental funding, the extent of governmental involvement or regulation, and whether the entity was created by government. Some activities of public agencies are not subject to the OPMA. They include certain licensing and permitting activities, quasi-judicial matters, matters governed by the Washington State Administrative Procedures Act, and certain collective bargaining activities. All meetings of the governing body of a public agency shall be open, and the public and all persons shall be permitted to attend any meeting of the governing body of the public agency, except as otherwise provided in the OPMA, such as during a declared emergency. A governing body is defined as a multi-member board, commission, committee, council, or other policy or rulemaking body of a public agency, or any committee thereof, when the committee acts on behalf of the governing body, conducts hearings, takes testimony, or public comment. Agencies governed by an individual, such as a single director, are not subject to the OPMA. Meeting means meetings at which action is taken. Physical presence of the members is not required. A meeting can occur by phone or in some cases by email. I will talk more about email exchanges later in this training. A meeting does not need to be titled meeting. The OPMA also applies to retreats, workshops, and study sessions. In order for there to be a meeting, there must be a quorum of the governing body. A meeting does not occur if there is no quorum. We have talked about the fact that the OPMA applies to a governing body at a meeting. In order to qualify as a meeting, the governing body must take action. Action means the transaction of the official business of a public agency by a governing body, including but not limited to receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final action. A subset of action is final action. Final action means a collective positive or negative decision or any actual vote by a majority of the members of a governing body when sitting as a body or an entity upon a motion, proposal, resolution, order, or ordinance. Final actions must occur in public. Secret ballots are not allowed. A majority of the members of a governing body may travel together or gather for purposes other than regular meetings or special meetings, so long as no action is taken. And remember, action includes discussion of agency business. This means a quorum of members can travel to a meeting together, or they can gather at a public or private event, such as a festival or social function, so long as they do not collectively discuss agency business or matters. In the next segments, we are going to talk about the types of meetings where a governing body may meet. The first is regular meetings. Regular meetings are recurring meetings held in accordance with a periodic schedule by ordinance, resolution, bylaws, or other rule. State agencies file these notices of regular meetings each year with the Office of the Code Reviser. Regular meeting agendas are to be posted online on an agency's website 24 hours in advance. A special purpose district or city or town is not required to post an agenda online if the agency has an aggregate valuation of property in the taxation district of less than 400 million, a population of less than 3,000, and provides confirmation to the state auditor when filing its annual report that the cost of posting notices to a website would exceed 0.1% of the agency's budgets. These provisions exempting very small agencies changed in 2022. Certain notice requirements are required for special meetings. These include written notice 24 hours in advance of the meeting, provided to members of the governing body unless waived. The notice must be provided to local newspapers, radio, and TV stations that have a request on file with the agency. The notice must also be posted on the agency's website if it has a website. There is an exception for very small agencies, agencies with no FTEs or with no one whose job responsibilities, either by job description or by contract, with the responsibility to maintain or update the agency's website. The notice must be prominently displayed at the main entrance site and the meeting site unless the meeting is being held as a remote meeting or one where some or all members of the public are limited due to a declared emergency. The remote meeting provisions are new, and we'll be addressing those in just a moment. The notice must specify the time, place, and business to be transacted. Unlike regular meetings, where the agenda may be changed and final action taken on a matter which was added to the agenda, under special meetings provisions, the governing body is prohibited from taking final action on any issue not on the original notice. There is an exception to the notice requirement for emergency special meetings. Those are meetings involving injury or damage to persons or property, or the likelihood of injury or damage, where time requirements make notice impractical and increase the likelihood of injury or damage. New in the OPMA through the 2022 amendments are provisions addressing a governing body holding remote meetings. After the declaration of emergency by a local or state government or agency or by the federal government, and the agency determines that it cannot hold a meeting of the governing body with members of the public in attendance with reasonable safety, the agency may either hold an all-remote meeting without a physical location or hold a meeting with the governing body present but some or all of the public excluded. In either of these instances, the agency must provide an option for the public to listen telephonically or by using a readily available alternate means in real time, such as an available television cable broadcast or the internet. Any option selected may not require any additional cost to access the program. If the agency does not provide an option, the agency is prohibited from taking action except for an executive session as authorized under the OPMA. If your agency is holding an all-remote meeting with some or all of the public excluded, the notice of the meeting must include instructions on how the public may listen live to the meeting. An agency that held some of its regular meetings remotely prior to March 1st of 2020 may continue to do so with no declared emergency, so long as the agency provides an option for the public to listen as required for emergency remote meetings. Up to now, we've been talking about all the requirements to ensure openness and transparency. Under the OPMA, there are enumerated instances where the governing body may convene outside of the public's view in executive session, or if the governing body is discussing matters not subject to the OPMA. An executive session may occur as part of a regular or special meeting. The grounds for holding an executive session are limited to the purposes listed in the OPMA and are narrowly construed. The purpose of the executive session and the time it will end must be publicly announced before excluding the public, and the time can be extended by further announcement. Examples of purposes include certain real estate transaction discussions, reviewing negotiations on publicly bid contracts, evaluating the qualifications of an applicant for public employment, and meeting with legal counsel regarding enforcement actions, litigation, or potential litigation. The OPMA provides a list of authorized executive session purposes at RCW 4230-110. An agency must carefully follow the law when meeting in an executive session. For example, when meeting in an executive session under the OPMA to discuss agency enforcement actions, litigation, or potential litigation, there are 3 requirements. First, legal counsel representing the agency must be present. Second, the purpose is to discuss an agency enforcement action, litigation, or potential litigation to which the agency, governing body, or a member acting in official capacity is a party or is likely to become a party. And finally, public knowledge regarding the discussion is likely to result in an adverse legal or financial consequence to the agency. Remember, an agency can discuss only those matters in an executive session under the OPMA that it has told the public it would discuss. The members cannot talk about other topics in that executive session. In addition to an executive session, a public agency can have a closed meeting to discuss matters not subject to the OPMA, such as deliberating on a quasi-judicial matter or collective bargaining. Other laws may provide additional procedures or authority for particular meetings or hearings to be closed to the public. There may be additional laws for particular agencies as well. As we discussed, all meetings of the governing body of a public agency shall be open in public, and all persons shall be permitted to attend any meeting of the governing body of a public agency, except as otherwise provided in the OPMA. An agency also cannot place conditions on attendance, such as requiring persons to register their names or fill out a questionnaire before attending. This provision does not prohibit any generally applicable condition determined by the governing body to be reasonably necessary to protect public health or safety, or to protect against interruption of the meeting, including a meeting at which the physical attendance by some or all members of the public is limited due to a declared emergency. As noted, email or phone call discussions amongst members of a governing body can be a meeting under the OPMA. But the purpose of the OPMA is to permit the public to attend and observe agency meetings. So when the public is unable to attend email or phone call discussions that are meetings under the OPMA, the act has been violated. Recent amendments to the OPMA make it clear members of a governing body can participate in meetings remotely with no declared emergency. However, public attendance must be maintained. In doing so, it is generally agreed that public notice procedures must be satisfied, and the agency has to set up a process for the public to attend, such as a speakerphone available at the agency's official meeting location, so the public can hear the discussion. In contrast, since an email exchange amongst a quorum of the members of a governing body is not open to the public, such an exchange in which an action is taken is a meeting that would violate the OPMA. And remember, action is broadly defined. It is very difficult to envision a way in which those email exchanges comply with public notice or attendance requirements for a regular or special meeting. One of the 2022 changes to the OPMA is a requirement that public agencies receive public comment at or before every regular meeting at which final action is taken. The 2022 amendments allow agencies to accept public comment either by written format or orally. If the governing body chooses written public comment, it can be submitted before or at the meeting. Any written comment received must be distributed to the governing body. The governing body may set reasonable deadline for submission prior to the meeting. The oral comment option is very similar to what many agencies were doing voluntarily before the 2022 amendments. Agencies can put reasonable procedures in place to allow for public comment. This may include limits to the time available for public comment or limit comment to those topics on the agenda. However, a governing body may also choose to accept public comment on any topic. If oral public comment is taken by the governing body, it shall, when feasible, provide an option for remote public comment for individuals that have difficulty attending. Difficulty attending may be due to a disability, limited mobility, or for any other reason that makes physical attendance difficult. A governing body is not required to accept public comment that renders orderly conduct of the meeting unfeasible. The OPMA has procedures for dealing with disruptions where orderly conduct of the meeting is unfeasible. The minutes of all regular and special meetings, except executive sessions of such boards, commissions, agencies, or authorities, shall be promptly recorded, and such records shall be open for public inspection. The OPMA does not require an audio or video recording of a meeting. Many agencies choose to do so. Public agencies are encouraged through the 2022 amendments to make audio or video recordings of meetings, or to provide an online streaming option of all regular meetings of the governing body, and to make any recordings that the agency does make available online for a minimum of 6 months. Violations of the OPMA can result in a lawsuit against an agency and its members. A court can impose a $500 civil penalty as personal liability against each member who knowingly violates the OPMA, and a $1,000 penalty for a subsequent knowing violation. A court can also declare any action taken at a meeting not held in compliance with the OPMA null and void. And a court will award costs and attorney's fees to a successful party seeking a remedy under the OPMA. To recap, this presentation covers the highlights of the OPMA. Public agencies may be subject to other laws governing other particular meetings, hearings, procedures. Some agencies have particular laws that govern their meetings as well. Like the OPMA, the laws concerning agency meetings and hearings can also be amended from time to time. Therefore, agencies are cautioned to be mindful of all current laws concerning their meeting and hearing procedures. Thank you for watching the Attorney General's OPMA training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Open Public Meetings Act. An official should first consult with his agency's counsel for routine assistance and training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Open Public Meetings Act.
Hi, I'm Bob Ferguson, your Attorney General. With me in this video is the Open Government Assistant Attorney General, Nancy Creer. This training video provides a basic overview of our Public Records Act for both records requesters and state and local agencies. It's intended to provide greater understanding of the legal requirements around the Act. The Public Records Act is a law created by an initiative vote of the people in 1972, which provides the public access to the records of government agencies. It received 72% of the vote. The purpose of the Act is to provide the public full access to information concerning the conduct of government, mindful of individuals' privacy rights, and fulfill the desire for the efficient administration of government. The law is based on the principle that open government is essential to a free society. All state and local agencies must comply with the Public Records Act. All public records must be disclosed unless a law exempts records or information. There are well over several hundred exemptions. Some of those exemptions are listed in the Act, but many exist in other state and federal laws. The Act is a broad mandate interpreted in favor of disclosure, and its exemptions are narrowly construed.
This training presentation is based on the Public Records Act and the Attorney General's Advisory Model Rules. The rules are online at the Attorney General's website at www.atg.wa.gov. They provide examples of steps to comply with the Public Records Act. An agency may adopt any part of the model rules into its own rules. Local agencies should consult the model rules when establishing local Public Records Act ordinances. The model rules provide comments that are useful for interpreting the Public Records Act and for training agency personnel. The model rules are non-binding, but they are based on extensive outreach, court decisions, and have been cited favorably in some court cases. This training video was prepared in the fall of 2017. The model rules were being updated in 2017. The legislature also amended the Public Records Act in 2017, and the legislature can amend it again in the future. The courts can also interpret the Act. Consequently, and as a reminder, there may be developments in the law after this video is prepared. Several updates on the law are often posted in materials on the Attorney General's Office website on the Open Government Training page. A PowerPoint on that page also provides training on the Public Records Act. This training video contains 16 short segments where we will review history, purpose, and intent of the Public Records Act, scope of the PRA, general obligations of an agency, what is a public record, requests for records, initial agency responses, reasonable estimates, adequate searches, disclosure, electronic records, managing broad requests, exemptions and withholding, fees, other records provisions, liability, and finally, additional resources. You have just heard from the Attorney General about the history, purpose, and intent of the Act. The Act regulates the disclosure of public records. The Act requires disclosure of public records unless a law permits withholding of a record or part of a record. The Act has many components, and compliance requires training. Training can be the difference between a satisfied requester and expensive litigation. The Act applies to both state and local agencies. A state agency includes every state office, department, division, bureau, board, and commission. A local agency includes every county, city, town, municipal corporation, special purpose district, and other forms of local government. In some cases, an entity which is not an agency can still be subject to the Act when it is the functional equivalent of an agency. This determination depends on whether it performs a government function, receives government funding, the extent of government involvement or regulation, and whether the entity was created by government. Courts are not subject to the Act. Agencies must appoint a public records officer responsible for being a point of contact for the public and for overseeing compliance. The name and contact information of the public records officer should be published with information on how to submit requests for records. The public records officer must have received training on the Act within 90 days of assuming his or her duties. Agencies must also publish information on the agency organization, rules, and procedures, and an index of specific categories of records. Agencies are required to adopt reasonable rules to provide full public access to public records, to protect public records from damage or disorganization, to prevent excessive interference with other essential functions of the agency, and to provide the fullest assistance to inquirers. Agencies may wish to consult with their attorneys when developing their rules and procedures. A public record is any writing relating to the conduct of government which is prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristics. It could be an email, text message, paper, letter, or memo, an audio or video recording, a picture, image, map, or any recording of information or data compilation from which information may be obtained or translated. A public record is not just what an agency creates, but includes documents created by citizens or private companies that are used or received by a government for a governmental purpose. A public record may also include documents not possessed by the agency, but which were used by the agency. For example, the courts have described that work documents on the personal computer, personal cell phone, or personal email account of an agency employee or official are subject to a request under the Public Records Act. Records of certain volunteers are excluded from the definition of public record. Records are excluded when they are not otherwise required to be retained and are held by volunteers who do not serve in an administrative capacity, have not been appointed by the agency to an agency board, commission, or internship, and do not have a supervisory role or delegated agency authority. Any person wishing to inspect or copy public records of an agency should submit the request to the agency, preferably in writing, using the agency's request form. The Public Records Act doesn't prescribe any official format for a valid request, so an agency must honor valid requests for identifiable records regardless of the format of the request. While using an agency's form is not required, it is typically the most efficient way to submit a request. A requester who chooses not to use an agency form must give the agency fair notice that he or she is submitting a request for public records. Agencies are required to honor requests received in person during an agency's normal office hours or by email. If an agency has adopted reasonable rules on how requests should be submitted, the agency may rely on those rules. The agency should be helpful to the requester in explaining how a request should be submitted and to whom. Records shall be available for inspection and copying upon request for identifiable records. So requesters should give a reasonable description of the records, enabling the agency to search for potentially responsive records. A request for all or substantially all of an agency's records is not a proper request for identifiable records. A request regarding a particular topic or containing a particular keyword or name shall not be considered a request for all of an agency's records. A request for information is not the same as a request for public records. The Public Records Act does not apply to requests for information. There is no duty to create a record that does not exist in order to fulfill a request for records or information. However, requests for information are at times easier to fulfill. Fulfilling a request for information may avert a large public records request. An agency must promptly respond to public records requests. Within 5 business days of receiving a request, an agency must respond. An initial response may be any one of the following: acknowledging receipt of the request and providing a reasonable estimate to respond, or fulfilling the request, or providing an internet address and link to the records on the agency's website, or seeking clarification while also, to the greatest extent possible, providing an estimate of time for further response if the request is not clarified, or denying the request with an accompanying written statement of the specific reasons. Reasonably clear requests for identifiable records may require no clarification. However, some requests are unclear. Seeking clarification permits the agency to identify responsive records, which in turn will aid in determining the scope of the request. Clarifying a request provides the fullest assistance to the requester so that the requester receives and pays for only those copies that are desired. Clarification may also result in prompt disclosure by identifying only those records desired. An agency should not seek clarification if the request is for identifiable records and is reasonably clear. If the entire response is unclear and the requester fails to respond to the agency's request for clarification, the agency need not respond to it. However, the agency must respond to those portions of a request that are clear. An agency may deny a bot request, which is a request that was automatically generated by a computer program or script when it is one of multiple requests from the requester received within a 24-hour period. The agency must establish that responding to the bot request would cause excessive interference with other essential agency functions. A requester is typically not required to provide the reason for a request, unless a law necessitates additional information from the requester. Agencies and requesters are encouraged to promptly communicate with each other if there are issues regarding a request. An agency's initial response to a public records request must provide a reasonable estimate for the time to respond when more time is needed. A reasonable estimate should account for many factors, including the time to have the requester clarify the request if needed, as well as time to assemble and review the records, provide notice to affected persons or agencies if needed, to redact exempt information, and to create a withholding or exemption log. An agency should not use the same estimate for every request. Rather, each reasonable estimate should be based on factors such as the complexity of the request, other pending requests, agency resources, and other agency essential functions. It's a good practice for an agency to briefly explain to the requester the basis for the estimate in the initial response. Extending the estimate is appropriate when circumstances have changed or additional information has come to light. Agencies are encouraged to briefly explain the need to revise an estimate. An agency bears the burden of showing that its search was adequate. Consequently, agencies should be able to document how a search was conducted and, for example, what search terms it used, as well as the location searched. An adequate search depends on the facts of each request, but it is one that is reasonably calculated to uncover all responsive documents in whatever form, paper or electronic. An agency must make more than a perfunctory search and follow obvious leads as they are uncovered. The search should not be limited to one or more locations if there are additional places where responsive records are likely to be found. If responsive public records are likely to be found on or in an agency employee's or official's personal device or account, the employee or official must search those devices and accounts for responsive records. It is possible to conduct an adequate search and still not locate a responsive document. However, if a responsive record is not located and or if challenged in court, the agency will have to prove its search was adequate. An agency must make records available during its customary office hours for a minimum of 30 hours per week. Public records are presumed to be open for inspection and copying unless a specific law exempts the record or information from disclosure. Agencies can deliver copies of records to a requester in a number of ways, such as providing links to the records that are on the agency's website, providing paper copies of paper records or scanned copies of paper records by mail or making them available for pickup, or providing electronic records by various methods. You may recall that with respect to what is a public record, the Public Records Act does not distinguish between paper and electronic records. Most agencies create records in an electronic format. A copy of an electronic record should be produced in the requested electronic format if reasonably feasible. Translating a record into an alternative electronic format at the request of the requester, or scanning a paper record, is not creating a new record. Metadata is information embedded in a document that provides detail about the document's characteristics. This may include information such as when the document was created, edited, recipients, and so forth. Non-exempt metadata must be disclosed when expressly requested. When agencies obtain new technologies, they should consider not only the agency's business operation needs, but also records retention and disclosure requirements. Examples of such technologies are portals through which records can be requested and delivered, electronic redaction tools, or retention software, just to name a few. In addition, agencies can look at whether they could make use of their current technology more robust. The legislature encourages agencies to make public records widely available electronically, particularly commonly requested records. For example, an agency could make commonly requested records available on its website. Then, as noted earlier, an agency could fulfill its obligation to provide access to a public record by providing a requester with a link to a specific agency webpage containing the electronic copy of the requested record. For requesters without access to the internet, an agency could provide a computer terminal at its office. Agencies should develop policies addressing technology concerns, such as if and when agency employees may use personal devices for public agency uses, and what responsibilities and requirements therefore attach to the employee. An agency may receive a broad request that asks for any and all records related to a topic. Agencies may not deny a request solely because it is overly broad. As noted, a request for all or substantially all of an agency's records is not a valid request. But a request for all records regarding a particular topic or containing a particular keyword or name is not a request for all of an agency's records. After an initial search shows there are potentially hundreds or thousands of different types of responsive or potentially responsive records, a public records officer should contact the requester to explain the estimated total number of records that would need to be searched, or provide other information describing the anticipated scope of the search. Then the agency could seek clarification to ask if the requester wants all of the different types of responsive records and is willing to pay for all the copies, or instead, if the requester is seeking only some of the records. Good communication can assist both the agency and the requester. A broad request will usually result in a longer estimate of time for disclosure, as well as producing records in batches or installments. When seeking clarification, to the greatest extent possible, the agency must provide a reasonable estimate of time the agency will require to respond to the request if it is not clarified. In many instances, a requester will narrow the scope of the request to enable the agency to provide disclosure more promptly and less expensively. An agency may manage broad requests in a couple ways. An agency may require a deposit in an amount not to exceed 10% of the estimated cost of providing copies for a request. If an agency makes copies in response to a request available on a partial or installment basis, the agency may charge for each part of the request as it is provided. If an installment of a records request is not claimed or reviewed, the agency is not obligated to fulfill the balance of the request. Finally, use of electronic technologies to search, review, redact, and disclose public records can reduce overall costs of compliance for agencies. Agency responses denying in whole or in part inspection or copy of any public record shall include a statement of the specific exemption authorizing the withholding of the record and a brief explanation of how the exemption applies. Exemptions exist throughout the Public Records Act and other state and federal laws. Common exemptions include information such as personal information in files maintained for agency employees if private, pending investigative files compiled by law enforcement or agencies with authority to discipline members of a profession, the non-disclosure of which is essential to effective law enforcement or for the protection of any person's right to privacy, educational records of students in public schools, attorney-client privilege information or work product related to litigation, or protected healthcare information. There is no statute providing a general privacy exemption. If privacy is an express element of a specific exemption, it is only invaded if disclosure would be both highly offensive to the reasonable person and also not of legitimate concern to the public. Exemptions in the Act must be construed narrowly. The general rule is that an agency redacts or withholds only the exempt information and produces the non-exempt information. An acceptable way of providing this information to the requester is with a withholding index, often called an exemption log. The information provided as part of the log should include a description of the type of record or part of record denied. The description should include identifying information from the document. For example, whether the document is a letter or email, the date the document was created or other relevant date, the total number of pages, and the sender and recipients. The exemption log must also include the statutory authority making the information exempt and a brief explanation of how the exemption applies. Some of this information will be evident on the face of the document where redactions have been made to only part of the document. An exemption log, the written explanation, also may be provided in different formats. For example, may be handwritten or compiled in a spreadsheet or chart, or in a letter, or redactions are marked on the records with exemption codes, and the requester is given the key to the codes. The format of the exemption log or exemptions is not relevant so long as the required information is provided. Any person may inspect non-exempt public records for free. An agency may not charge for the time of staff to search, review, or redact public records when preparing them for inspection. If a requester wants copies of records, an agency has options to charge for copies. It can charge actual costs, or it can charge default fees listed in the Public Records Act, or it can charge an alternative up to $2 fee for an entire request. Some other provisions may be relevant too. In order to charge actual costs, an agency must make available for public inspection and copying a statement of the actual per page or other costs and how it determined actual costs. An agency may adopt its statement of actual costs only after providing notice and a public hearing. When calculating fees, the agency must use the most reasonable, cost-efficient method available to the agency. Staff time to copy and deliver the requested public records may be included in an agency's costs, but an agency may not include staff salaries, benefits, or other general administrative or overhead charges unless those costs are directly related to the actual cost of copying the public records. An example of when an agency may want to charge for the actual costs of staff time is where an agency scans paper records and copies them into an electronic format. The charges should be reasonable and related to the wage of the person likely to be repeatedly assigned to this task. If an agency does not have staff available to make copies, for non-exempt records, an agency may send a scanning or copying project to an outside vendor and pass on the actual cost to the requester. Electronic copy costs may include the actual cost of the electronic production or file transfer of the record, the use of any cloud-based data storage processing service, and the cost of transmitting electronic records, including the use of a physical media device. A second method to charge copy costs is for an agency to choose to use a statutory default fee schedule provided in the Act. In that case, an agency need not calculate actual costs if it has rules or regulations declaring the reasons doing so would be unduly burdensome. The statutory default fee schedule lists, for example, per page costs for paper records, scanned records, and costs for electronic records. As yet another alternative, an agency can assess an up to $2 flat fee for an entire request when certain conditions are met. The Act includes other fee provisions. For example, an agency cannot charge for access to or downloading of records it routinely posts on its website prior to the receipt of a request, unless the requester has specifically asked that the agency provide records through other means. An agency may impose the actual cost of a customized service charge when the request would require the use of IT expertise to prepare data compilations, or when such customized access services are not used by the agency for other business purposes. The agency must notify the requester and take other steps if it chooses to do a customized service. An agency can require an advance 10% deposit before making copies. An agency may enter into a contract, memorandum of understanding, or other agreement with a requester for an alternative fee arrangement, or in response to an extensive or frequently occurring request. An agency may choose to waive any charge pursuant to agency rules and regulations. Upon request, an agency must provide a summary of the applicable charges before making copies. The requester then may choose to revise the request to reduce the number of copies and the cost. In sum, the Public Records Act provides an agency several options for assessing charges for copies. The choices selected may vary from agency to agency. Under a different law, the records retention laws at RCW 40.14, agencies must maintain a log of public records requests, including for each request, the identity of the requester if provided, date of receipt, text of request, description of records produced, description of records redacted or withheld and the reasons for doing so, and the date of final disposition. With respect to the identity of the requester, it is possible an agency received only an email address from the requester, and if so, that address would be included in the log. The logs must be retained per the agency's records retention schedule and are a public record. The records retention law also provides that agencies spending at least $100,000 to fulfill requests during the prior fiscal year must report 17 data points about their PRA requests to the Joint Legislative Audit and Review Committee. Under the Public Records Act, any person having been denied an opportunity to inspect or copy a public record may seek further review in the agency. The person may also file a lawsuit to enforce his or her right to access public records. A requester can also file a lawsuit if he or she believes that an agency has not made a reasonable estimate of the time or of the charges to provide public records. Such a lawsuit is to be filed in a court within 1 year of an agency's final definitive response to a request, such as a final claim of exemption or the last production of public records on an installment basis. The agency has the burden of proof to demonstrate that public records were lawfully denied or its estimates were reasonable. If it does not make this showing, an agency will pay the requesters reasonable attorney's fees and costs, and may pay potential penalties for denying records in violation of the Public Records Act. A court will consider mitigating and aggravating factors in determining a penalty amount. Lawsuits for public records can be extremely time-consuming and expensive for agencies. Understanding and correctly applying the law is a good risk management tool for state and local government. In rare cases, individual employees may also be civilly or criminally liable under other laws. State agency employees and state officers are subject to the Ethics in Public Service Act. It is a violation of that state ethics law for a state employee or officer to intentionally conceal a public record required to be released under the Public Records Act. State agency employees and officers may be fined up to $5,000 per violation of the state ethics law. It's also a crime for any agency officer to willfully mutilate, destroy, conceal, erase, obliterate, or falsify any record of that agency's office, except where the law expressly authorizes the non-disclosure or destruction of records. The crime is punishable by imprisonment of up to 10 years or a fine of up to $5,000 or both.
Thank you for participating in the Attorney General's Open Government Training. For more information, there are available resources for agencies to receive training and technical assistance for compliance with the Public Records Act. An employee should first consult with its agency's public records officer for routine assistance or training. Additional resources are listed on this website. The Assistant Attorney General for Open Government is also available to provide information about the Public Records Act. Thanks again for watching.
It's a slide. It's one slide. All right. I'm just going to read that. The district records officer, superintendent, or designee shall have the responsibility for the safekeeping of all records according to the standard retention schedule for K-12 public schools and educational service districts. We have a current district policy and procedure that you can review, 6570 and 6570P. And there's also, you can review the Office of Secretary of State records retention schedule for specific timelines. Both those are all those items are attached in your agenda, so you can review those. If you have any questions to that, please don't hesitate to reach out to myself or Dr. Peter Finch. And thank you. Your training has concluded.
Who is the records?
I got to do most of that. But if you guys have questions specifically, what's that? No, we use the standards like 6 years.
So just in case it wasn't picked up on the question was asked, who is the records custodian for who's the designated person, the records custodian, and that's Joe Conley. So with that, that concludes the study session on open government records training. It is 6:53 rather, and we will adjourn the study session at this time. We'll come back into the regular school board meeting at the top of the hour, 7 p.m. Thank you. Okay, we ready? All right. Good evening again, everybody. It's 7 o'clock. Welcome to the West Valley School District Board of Directors regular school board meeting. Is Tuesday, February 13th, 7 p.m. I will call the meeting to order with the Pledge of Allegiance, which is stage left. Ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Gosh, just about fell. Before we move on to the agenda, I'd like to make a motion to excuse Mark Strong, who is attending his daughter's basketball game this evening. And I'll call for a vote. All those in favor, please signify by saying aye. Aye. Opposed, same sign. Motion carries to excuse Mr. Strong 4-0. Are there any changes to the agenda?
No, there's not.
Okay. Item 5, communications. 5A, response to public comment.
There is no response. There is no public comment.
Okay. And then we have a communication regarding the one-day emergency school closure at Mountain View Elementary.
Yes, for the water line break. So we had 1 day of closure. So we're applying for the OSPI waiver request. And that's in front of you there.
So that's basically just for our information.
That
We
is
don't
correct.
need to take action. And the waiver is such that we don't have to make up the school day at the end of the year.
That is correct.
Okay. Thank you, Mr. Conley. On to item 6. We're happy to be here at White Hollow. Principal Rick Ferguson, I'm sure, has a wonderful program in store for us. Would you, do we just sit here or do we come to the audience? What would you
It'd be
like?
great if you could come to the audience. I had you in a different spot this morning, but apparently we needed internet access for you guys.
Thank you.
All right, so welcome. I'm really excited to have you guys here tonight because we're going to highlight a program that is in its first year, and it's a partnership with Community in Schools. And Community in Schools is just an amazing organization. In schools, we have a lot of needs. We're the second largest elementary school in West Valley. We're also a school that has high poverty, and a lot of our families need support. And Community Schools comes in and has partnered with us and done some amazing things to meet the basic needs of our families and our kids. And we all know that if basic needs are not met, it's really hard to learn. And Community Schools does a great job of meeting those basic needs. So I have invited our Community in Schools partners here tonight to highlight what Community in Schools, what they do, and kind of talk about their programs and at the end, I'll talk a little bit about what I've seen anecdotally just as a principal of a school, having a Community in Schools representative in your school. So tonight I'd like to introduce Leslie Gomez. Leslie is the program manager for Community in Schools. And then we have Maura Ruiz here, who's the executive director of Community in Schools. And then we have our wonderful Noelia Kazar, who is our student and community advocate here at White Hollow Elementary. So without further ado, I will turn it over to them for their presentation.
Thank you, Principal Ferguson. It's really an honor to get a chance to speak to the board today. We feel very privileged to be able to share our work, and we are grateful for the partnership at West Valley School District and what we've been able to do. I have for you a few slides talking about our national backing as well as our affiliated network throughout our state model and how that footprint and service aligns to the work that we're bringing to your schools. So far, we are 2 site coordinators into the West Valley School District, and Noelia happens to be the Wide Hollow Elementary site coordinator, school and community advocate. And we also have a representation with Mr. Julio Santana, who is the student community advocate at the mid-level campus. For history, we have a national backing. Communities and Schools actually started it in the 1970s through a needs model on our east coast of our state. So as you can see up on your screen, those are all of the states that Community Schools has a footprint in. A little tidbit is that Washington actually has the second highest footprint in terms of community school supports within the national model. When it comes to our state, we started in the 1990s, a lot of influx through the I-90 corridor on the west side. When it comes to Communities and Schools of Central Washington, we are the newest affiliate that was actually brought upon ESSER funding through Yakima County. So they approached us and they said, how can we get Communities and Schools to start an affiliate in our region? Since then, we've been able to expand our work and supports, and that's what I'll be talking to you about today. So we were established in 2021. We have a Washington footprint that ranges from Yakima County, Kittitas, and Klickitat. As a state, we have served over 90,000 students, and our mission is simply to remove any types of barriers for students in partnership with schools, bringing in community supports to enhance and add values to what schools have to offer. If you could go to the next slide for me, please. And you may be asking, how do we do this? We do this with our integrated student support model. So this model allows us to bring in from our affiliate a site coordinator like Ms. Noelia. We collaborate with partners to do a comprehensive school needs assessment where Ms. Noelia is tasked with analyzing the supports of the school that the school might need. So we are coming in, talking with teachers, stakeholders, district partners, parents, students, and we are asking, what is it that the school needs? What barriers are they? What do they do well? And we work together to provide that needs assessment in order to plan and integrate student supports in 3 aspects. So our first aspect is a school-wide support. That means all services and supports that are school-wide are offered to students. And then it's up to the student or the families or the teachers to be able to advocate to get students in a tier 2 support and a tier 3, which is a group level support. Sometimes our groups might be enhancing the footprint for our McNevento students because they need a lot more support. For our migrant students, ELD, SPED, IEP students, that's where that group level of support comes into. And then we have individualized supports. So after we do a comprehensive school needs assessment, the support plan kicks in, and the support plan helps dictate how these supports are instructed, according to our 10 areas that we're able to support in. So Noelia sits down with Principal Ferguson and says, hey, we might need to boost our basic needs. We have a lot of students here that need basic needs and they're struggling. How do we weave in community partners? How do we partner with our churches, other entities to make that happen? We also have timelines that we do with our principals and our stakeholders. So as a school district, you receive access to that comprehensive needs assessment, to that support plan, again with monthly reports, mid-year evaluations, because part of the model is to monitor and adjust our plans and supports if they're not working. What is it that we can do if we can reevaluate and enhance that support and bring something further according to these 10 areas? Again, our students, the one-on-one supports, those are to capture the students who have the highest need and supports for students. So Ms. Noelia is going to talk about how she integrates the model into the school and how we weave in community. So, all of you there.
Yes. So again, my name is Noelia. I'm the student community advocate here at White Hollow. My main focus here is to enhance and coordinate the services and resources from the district and also our community. And I've been able to do that in various different aspects. So the first one is, how am I going to provide resources and coordinate what are going to be my goals? So my first goal for this school is going to be, how can we keep our attendance high or even improve our attendance? But also, how can I incorporate more parents into the school, especially those parents who are Spanish speaking? I've been able to help with enhancing the services of parent conferences. I'm in parent conferences of those case managed students. This is what we're doing. This is what's helping with them. What else can we do? How else can I support your family? I've been able to coordinate family events. I coordinated pictures with Santa. So we got a community member donating their time and services of photography, bringing in a Santa, taking those pictures that otherwise those families couldn't get. I've been able to do monthly classroom attendance. So making sure that our attendance is high. What can we do? Start rewarding our kids. You're here. This is the class that had the best attendance. You guys get a special reward for the month. I started noticing that there are a lot of basic needs in our school. So then I started coordinating with jail. How can Ram Landing be more enhanced and more accessible to our community, and especially to White Hollow, and then creating a mini Ram Landing. So in the classroom that I am, I have a little setup of a mini Ram Landing where there's clothes that family can just come on in and pick whenever they need, because many of our families don't have transportation, don't have a way to get to Ram Landing. So how can I support with you still getting those services, but not having that barrier of transportation? You need basic needs as hygiene supplies. Come on in, I have it. I don't have it, I can call Jill. I can try to put in my monthly budget, see what I can do, call community resources that I have. How can we get the support for our family? There is also canned food items already that we can't wait until the middle of the week, where when we get our new boxes from our outside community members, we'll come on in, let's see what we can get you in the meantime. Not mini Ram Landing, meeting those students' basic needs has really contributed to many of our students. For instance, I have a student here, Mrs. Gwynn, who she has been one of the families that is benefiting from mini Ram Landing. We're meeting her basic needs, trying to see what it is that she needs and eliminate those barriers to get her to school. Not only that, but building those connections with those students. I'm here for you. I'm going to be here with you. I'm going to support you. And slowly, she has been coming to school very consistently. Her attendance has improved greatly. She was out sick about a week ago, and then mom sends me a message on Remind. She is so sad. She is missing school today, and she just wanted me to message you. And I just replied back like, hey, tell her it's okay. She's sick. She can be at home, and when she's feeling better, she'll come right back. And that's exactly what happened. There are different fundings and services for our students, but sometimes we don't have after-school programs for students that are kinder through second grade. So then I integrated an art club. So we can start having an art club for them, so they can get different services as well, and like help parents out, because some need to stay at work a little longer. So we incorporated that. And then doing attendance outreach to those specific high needs students. But then we want to focus more specifically. I do have the breakdown of basic needs that I've been able to provide at White Hollow. I know at the very corner, there's going to be a total number of units provided, and I think it was about 1,200. It's 1,272. And then all of those services, we also put a cost to it. How much is it that they are getting? And so far, this has been updated up until the end of January. It has been $17,143,000 that have been given out. And that is, again, on basic needs such as a hotspot, clothing, food, hygiene products, school supplies. Other assistance can be like the incentives that I give out to families. We're just trying to put all of our services from our model to helping directly the students at White Hollow. You guys have any questions for us, or take it back to Rick?
No, we have time for questions. Let's do questions first.
So if somebody an individual or a group or a church wants to donate, can you accept donations for some of these products?
We do. I do sometimes connect with the church. For instance, the church across the street, they connected with me. Hey, we need students for their holiday event that they do. Can you help me with that? I'm like, oh yeah, I can help you connect with these families, give them the families. But then she would also say, if you need something, you let me know. So then I can just call her and be like, hey, can you really help me out with this? And then she'll see like, hey, what can I do? And she'll talk to the church, and then they will bring me stuff.
We have over 13 community partners that are actively working to support our work, whether it's providing in-kind donations, providing supports specific to a school. We talk to the Walmarts, we talk to the McDonald's, the Costco's. How can you bring in services that all families have access to? Hotspots would be a great example for accessibility for students. A lot of hygiene backpacks donated from Amazon for students who may not have the resources and supports to be able to help students where they're at. Noelia incorporates an art club, but what she failed to mention is SEL is a big component. So students are doing art per se, but they are also working on strategic learning opportunities, such as how to be a good listener, how to share, how to be respectful when you're composing those art instruments. And the example that she shared about the programming, right? Family engagement is one of her roles. She was able to bring in meals for the families, coming from the coffee that was donated from Starbucks to the piñatas that the students had a chance to learn about historically and culturally. What does that mean to families? How are you represented within a school building, and how can you be seen, right, in other ways? From the Santa Claus that was brought for our families who may be under-resourced and might not be able to afford a picture with Santa. How are we bringing in community partners to enhance the work that happens within school buildings, but within the district as well? So you can see how the improvement of climate and culture really comes to life with the work and integration of precise site coordination. Each student that comes to us has a holistic needs assessment, and Noelia is checking about their family, checking about how they make connections with their friends, checking about how they feel comfortable in school, how they like to learn. And all that comes into support these tiers of models and all of the items that are brought in to help support the school in ways that they want to feel supported and they feel that they can encompass needs.
You mentioned that it was started and funded by ESSER funds. Is there a plan for next year with the change in ESSER funds?
Yes, as a nonprofit, we are purview and we are grateful that we get to apply for other funding structures. Some of that funding comes from school districts and what they're able to weave in. Some of that funding comes from private funds, from state funds, from federal funds. And the reason why we came into West Valley is because they took a chance on us and they wanted to partner with us to make it happen because they knew that this was a critical support for students. So we actually have supports that are coming into the school so it doesn't fall into just district funds. So we're happy to be able to weave opportunities that might not be disposable to a school district per se, but to come in with those partnerships, maybe partner with a grant for future sustainability and make sure that CIS is here to stay long-term, because families are really seeing this need and so are school districts, and this is the perfect way to help implement and fill those gaps.
That was a great question because you actually answered how did the partnership come about between is it White Hollow and your organization? But is it just White Hollow, or are you servicing other schools within our district?
I am able to service anywhere from Kittitas to Klickitat to Yakima. And really, a lot of people are hearing about our work with communities and schools, and we just need to be able to hold to the capacity, but stick to the fidelity of the model. And so really, I would say I give all the kudos to Superintendent Peter Fitch. He sat in a presentation learning about communities and schools. He was interested, and together we were able to tackle funding sources to be able to sustain communities and schools and the footprint here for the next 3 years. So this is year one of our partnership, but we have funding to be able to sustain for year 3. And I'm actually in conversations with Stacy about how we can continue to sustain the footprint, but deepen into the other schools within West Valley who also see a need and can resource communities and schools.
So there is at the middle level though, so there's another
Okay.
training schools advocate at the middle level as well.
Great. That was that was
Two for
my,
now,
that was my
potential for
that was
more.
my follow-up question. Thank you.
You're welcome.
And just, from my perspective as a principal, I've been super impressed with how well trained and how well everything's monitored and the meetings that they hold with me as a building principal and with our community as far as actually identifying needs. It's been super impressive. And then just outside of that, Noelia is with us 5 days a week. She's in the building, she's with kids, she's out at recess, she's in their classroom, she is ever present. So she's not just a person that maybe brings a family food, she's also here at the school. And she's, she may have a kid in art club who she's working on attendance, who she's delivering food to all these it really is just amazing to see all of the things she can do with the 44 students that she case manages. And I've just seen some big changes in kids and families with her involvement. ESD 105, they got a large grant for about $12 million to have community and schools in place all through the Lower Valley. So it's really taking hold in this area. And I think it's because of the leadership in their organization and how organized they are and how well trained they are. I've been nothing but impressed by every step of the way with their involvement here at White Hollow. So it's been fantastic.
Thank you. Any other questions from the board? All right. Well, thank you very much.
Thank you.
Thank you. All right. On to item 7, which is public comment. Nobody signed up for public comment, but I'll open it up for public comment at this time to anybody that would like to address the board. Mr. Marinacci has his hand up. The floor is yours.
Good evening. I just want to draw the board's attention. There's a House Bill 2331. Excuse me. And if I read it correctly, this would give the state superintendent the power to cut state funding if he does not approve the classroom material chosen by local schools. And my view is I want a school board that's empowered to make local decisions, not by the state. So I just implore you guys to take a closer look at it, if I'm reading it correctly. And fundamentally, you guys are our representatives. So a decision that you need to think about is, do you guys want to be making the decision, or school board members that are local, or do you want the state to do it? My view, it should be local. Thank you.
Thank you. Any other public comments? All right, since nobody's running up to the microphone, I'll go ahead and close the public comment period. On to item 8, approval items. We have item 8A, which is approval of minutes from our study session school board meeting on January 23rd. Last month, the minutes were in the packet. I'd entertain a motion to approve the minutes as presented.
So moved.
Mr. Wolcott, thank you. Call for a vote. All those in favor, please signify by saying aye.
Aye.
Opposed, same sign. Motion carries on approval of the minutes 4-0. Next up, it's item 8B, approval of travel requests. We have 4 this evening. One is for a conference on directors, National Association of State Directors of Migrant Education, a national conference for CTE and boys basketball, hopeful in Tacoma, and also a tennis invitational in Kennewick in April. The information on those travel requests were in the packets. We can take these as a group if the board would like, and then entertain a motion, or we can take them individually, whatever the board pleases. Or if there's any questions, we can take those as well.
I'd motion to take as a group.
Okay. So there's a motion to approve the travel requests B1 through 4. Call for a vote. All those in favor, please signify by saying aye.
Aye.
Aye. Pose same sign. Motion carries on the 4 travel requests 4-0. Next up, we have second reading of 5 policies. Those are also in the packet. Any additional questions or comments? We can also take those as a group with the appropriate motion.
I move to take as a group.
Everybody's getting in on the action tonight for motions. Great. So we have a motion to approve the 5 second readings of policies in the packet. I'll call for a vote. All those in favor, please signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion carries. Second reading on 2190, 2413, 2415, 5005, and 5271. Items arising. All right. Superintendent's report.
Nothing to add than what's already written.
Okay. Board reports, board development.
I do have a couple comments from this board member. So I attended just a couple things just to let people know that I was very impressed. I attended a little bit of the JROTC competition for a couple hours on the 27th of January. Was able to watch some drills and then shooting competition, sit-up competition. And, I wasn't there the whole day by any means, but a lot of people were there all the way down from, I think, Oregon and Washington. And it was just a good experience to see everybody, excuse me, that was there participating. So look like a good day and a lot of people there. January 30th, it's in the superintendent's report, but just to add to it, I had the privilege of traveling to Olympia with Dr. Finch and 4 students to meet with 2 senators and 4 representatives. The students were able to share their experiences at the college and the high school and the Innovation Center with the legislators. And the students that went with us did a great job of sharing, and I could tell that the representatives were real impressed with the kids. And so that was just a good day together and getting to know the kids, students a little bit. And then last week I was on this campus with Dr. Finch and Principal Rick Ferguson visiting classrooms, and that's always a joy to walk around the different classrooms like I think most of the board members have done and are doing. That was really good. And last but not least, I just wanted to comment. I didn't know that Ms. Marinacci was going to comment on that. I was going to comment on that also. As the legislative rep, I do look at a lot of bills and try to see what's going on. And just personally, from this board member's view, I think engrossed Senate Bill 5462 and House Bill 2331 need to be looked at and make your own decisions on that. But I feel like if either one of those are passed, it does infringe on local control of the board. And I'm really getting concerned about that. I was concerned about that before I was on the board and as I'm on the board, because local control is being taken away by the legislature, in my opinion. And those 2 bills especially would highlight that. And the one bill, 5462, is going to be discussed at the House Education Committee tomorrow morning at, I think it's 10 or 10:30 a.m., and you can see that online. I would just encourage you to look those up and comment on the legislation according to your personal views. Thank you.
Thank you. Any other board reports? Okay. Item 12 is a closed session on collective bargaining update. Mr. Conley, how much time do you think we need? About 10 minutes. Okay. So we will go into a closed session for the purpose of a collective bargaining update for 10 minutes. We'll come out of that at approximately 7:40, taking no action at that time, and then we will be adjourning the school board meeting then. So, perfect. Where are we going? Back there.
Yep.
Okay. Okay, it's 7:42 and the meeting is adjourned. Thank you.